Welcome to the Deep Dive, your shortcut to understanding complex topics.
Today, we're diving deep into the express-trust relationship.
That's right. And we're drawing from materials made available to students by the University of London.
And it's important to say up front, this deep dive is purely for educational purposes.
Absolutely. Educational purposes only. We want to help you get your head around the core concepts, the key cases, the essential legislation, basically get you ready for exams.
Think of this as a focused study session on express trusts. We'll hit the main points.
So what's on the agenda then? What are we covering specifically?
Well, we'll look at the basic structure of express trusts for persons, focusing on beneficiary rights, trustee powers, and duties.
Okay.
And we'll also touch on some really important practical aspects like investment, delegation.
Yes, delegation. Always tricky.
And the beneficiary's right to information. And, of course, that big one, ending the trust under the rule in Saunders v. Vautier.
Saunders v. Vautier. Definitely one to remember.
Definitely. Our goal here, again, for educational purposes, using the University of London materials, is to map out the key things you need for your studies.
And we'll be using academic stuff, case law, some really crucial cases we'll mention a few times.
Yes, cases like Speet v. Gaunt, Uri Whiteley, Bartlett v. Barclays Bank Trust Co., Ltd., Nestle v. National Westminster Bank, and Cowan v. Scargill.
Got it. Key cases. And legislation too, right? Trustee Act 2000.
Exactly, especially the Trustee Act 2000. So the mission today is clear. Structure your understanding of express trusts, focus on those key ideas and cases for effective study, and, well, exam success.
We'll repeat the important bits, the terms, the cases, to help it all sink in. Sound good?
Sounds like a plan.
Okay, let's get started. Where do we begin? Rights and duties.
Let's start right there. It's fundamental. You need to get the difference between personal rights and property rights clear in your mind.
Okay, personal rights, like a contract, between specific people.
Exactly. Enforceable against a specific person. You owe me money under a contract, I sue you. Property rights, though, are different. Think about owning a book.
Right. My right is against anyone who tries to take my book.
Pretty much. It relates to the thing itself, enforceable against people generally. Now, a trust. This is where it gets interesting. It kind of blends both.
Oh, okay. So how does that work?
Well, trustees have personal obligations to the beneficiaries. Duties like keeping accounts, distributing the property correctly, investing the funds.
So if they mess up, say, lose money through carelessness, the beneficiaries can sue them personally.
Precisely. To make good the loss to the trust fund, that's the personal obligation bit. But beneficiaries also have rights linked to the trust property itself.
Property rights. So rights that might affect other people, not just the trustees.
In certain circumstances, yes. These rights can sometimes bind third parties. But, and this is a really key point for exams, beneficiaries don't usually possess the property.
Right. The trustees hold the legal title. Like, if shares are held on trust, the trustee gets the dividends.
Exactly, or votes at meetings. But they have to do it for the beneficiary's benefit. The beneficiary has the beneficial interest. The trustees have the legal interest. You don't physically hold the share certificate, usually.
Okay, so mostly rights against the trustee, but you said sometimes against others, strangers to the trust. When does that happen?
That happens if trust property is transferred in breach of trust, unless the person who receives it is a bona fide purchaser for value of a legal title without notice.
Whoa, okay. That's a mouthful. Bona fide purchaser for value without notice? Let's unpack that. Sounds like a legal shield.
It is, and you need all four elements. Break it down. Bona fide means good faith. They genuinely thought it was all above board.
Okay, honest belief.
Purchaser, they acquired a legal right by consent, like buying it, not inheriting it.
Right, not just getting it by chance.
For value, they gave consideration, usually money, but could be money's worth, not a gift.
Makes sense. Paid for it.
And the big one. Without notice. They had no idea, no knowledge, that the transfer was actually a breach of trust.
So all four have to be met for this stranger to keep the property safe from the beneficiary's claims.
All four. If anyone is missing, the beneficiaries might be able to claim the property back.
And notice itself.
Oh.
That's not always straightforward, is it? There are different types.
Correct. 3 types you need to know. Actual notice.
Mm-hmm.
They literally knew.
So simple enough.
Constructive notice. They didn't know, but they would have known if they'd made the sort of inquiries a reasonable person would make.
Like checking the land registry properly if buying a house.
Exactly that kind of thing. If the clues were there, you're expected to follow up. Ignoring obvious signs isn't an excuse.
Okay. And the third?
Imputed notice. This is where their agent, like their solicitor, has actual or constructive notice. That knowledge is imputed to the principal, even if the agent never actually told them.
Ouch. So you're stuck with what your agent knew or should have known.
Pretty much. The law assumes the agent communicates relevant facts.
Okay, so that covers who the beneficiaries can't recover property from. But what if the property has been passed on from the initial wrongdoer? That's where following and tracing come in.
Yes, exactly. Two distinct concepts. Following is tracking the same asset as it moves from hand to hand.
So following the actual shares, for example.
Right. Tracing is different. It's about tracking the value of the trust asset when it changes form.
Ah, so if the shares were wrongly sold and the money used to buy, say, a painting.
You might be able to trace the value of the shares into the painting. Even if the original recipient sold the shares to a bona fide purchaser, you can't get the shares back. Then you might trace the value into the sale proceeds they received, or whatever they bought with those proceeds.
But you can't always trace, right? When do these rights get lost?
They do have limits. Tracing stops if the asset is just gone, destroyed with no replacement, or if there's no exchange value, like if trust money was spent on a holiday, it's dissipated.
Gone. Vanished into thin air.
Or if the beneficiary's interest itself is somehow legally extinguished, like in that case, Buyers v. Saudi National Bank. A later legal event basically wiped out the claim.
Okay, so tracing and following are powerful tools, but not foolproof.
And remember, separate from these property claims, beneficiaries always have that personal claim against the defaulting trustee for breach of trust, and sometimes against third parties who assisted the breach, but that's more for topic 16, really.
Got it. So maybe we can quickly compare a trust to, say, agency or debt, just to highlight what makes a trust unique.
Good idea. Think about agency. If an agent collects rent for me, as in Morley v. Morley, usually it's just a debt they owe me. If the cash gets stolen from the agent before they hand it over, it's generally their loss. They still owe me the rent.
But if it was held on trust?
Then if the specific trust money was stolen, the loss would likely fall on me, the beneficiary, assuming the agent trustee wasn't negligent. Also, crucially, if the agent goes bankrupt.
Ah, bankruptcy. Always important.
If it's a trust, I can claim the specific trust money back, provided it's identifiable. If it's just a debt, I'm just another creditor lining up, likely getting pennies on the pound.
So the proprietary nature of the trust gives the beneficiary priority.
Exactly. That's the key difference from a simple debt. A debtor owes money generally. A trustee holds specific property for the beneficiary. You can even hold the benefit of a debt on trust for someone else.
Right. That really clarifies the unique position of a trust beneficiary.
Right.
Okay, let's shift gears. Powers and duties. Who has them? What are they?
Okay. Trusts can mix things up, fixed shares, discretionary pots, maybe interests that only kick in later, contingent interests. When we talk powers and duties, a really useful split for studying is dispositive versus administrative.
Dispositive. That's about giving out the property.
Yep.
Distribution.
Yep. Who gets what, when, how much. Administrative is about managing the assets, investing, insuring, paying bills, keeping records.
And it's not always just the trustees holding these powers, is it? Settlers can keep some control.
Sometimes, yes, a settler might keep the power to revoke the trust, for instance. But a huge concept here is fiduciary duties and powers.
Fiduciary, meaning acting in the best interests of others.
Precisely. Trustees' powers and duties are almost always fiduciary. They must exercise them in the beneficiary's best interests, avoid conflicts of interest. It's a very high standard. They can't benefit themselves or favor friends improperly.
So that trustee, choosing who gets money from a discretionary fund, has to be purely about the beneficiary's needs and the trust's purpose.
That's the ideal, yes. Contrast that with a personal or mere power. Someone holding that can consider their own interests. Like that settler's power to revoke, that's often personal.
But for a trustee managing the trust, usually fiduciary.
Usually fiduciary when dealing with the trust property. They have a duty to consider exercising fiduciary powers. They generally can't just release them or ignore them. Personal powers are more flexible. Use it or not, it might lapse on death. You can release it.
Okay, let's look at some common dispositive powers. Power of appointment. What's key there?
Right. A power of appointment gives someone the dunny the authority to decide who gets the property from a specific group, the objects. Crucially, it's usually a power, not a duty, so they don't have to appoint.
Unless it's held by a trustee, then it might be fiduciary, meaning they have to at least consider it.
Exactly. If a trustee is the done, it's usually fiduciary. They must think about it periodically. If someone else is the done, it could be personal. Know the terms. Done. Objects.
And there are different types. General, special, hybrid.
Yes. General power. Appoint to anyone, including yourself. Special power. Appoint only within a defined class, like my children,
Yeah.
hybrid or intermediate. Appoint to anyone except certain people or groups, like anyone except the settlor or their spouse.
Got it. And what if the power isn't used? Is the property just limbo?
Often the trust deed says what happens a gift over in default of appointment. Maybe it goes to someone else or gets shared equally among the potential objects.
And if there's no gift over?
Well, if it's clear the settler really intended the objects to benefit somehow, the court might step in, especially if it was a fiduciary power. Think Burroughs v. Philcox trusts. The court might order equal division among the objects if the power isn't exercised. It tries to achieve the underlying intention. Of course, if it's really a duty to distribute, then it's just a discretionary trust, not a mere power.
Okay. You also mentioned power to appoint individuals to a class.
Yeah, that's slightly different. It's about adding people to the group who could benefit. Say a trust is for existing employees, but trustees have power to add former employees to the potential beneficiary pool.
Right. Then there's maintenance and advancement. Sounds important for younger beneficiaries.
Very. These are statutory powers under the Trustee Act 1925, Sections 31 and 32, unless the trust deed says otherwise. Section 31, maintenance. Trustees can use trust income for the benefit, education, or maintenance of beneficiaries under 18.
Income for minors. Got it.
Section 32, advancement. Trustees can pay or apply trust capital for the advancement or benefit of a beneficiary. This applies even if their interest is still contingent or future.
Capital. Okay, so maintenance, income, advancement to colossment. And both are fiduciary powers for the trustees.
Yes, both fiduciary. Must be exercised for the beneficiary's benefit. Advancement usually requires the consent of anyone with a prior interest too.
And finally, you mentioned fraud on a power. Sounds bad.
It is. It's about using a power for an improper purpose, one the settler never intended. The key case is Vatcher v. Paul.
Vatcher v. Paul. Okay.
Classic example. The done appoints property to an object, but there's a secret deal for the object to give some of it back to the done, or maybe to someone who isn't an object at all.
So it looks okay on the surface, but the real motive is wrong.
Exactly. Vatcher v. Paul says it's about the intention. If the appointment is a means to benefit a non-object, it's a fraud on the power and can be set aside.
Okay, that covers dispositive powers really well. What about the admin side, the day-to-day running?
Right. Administrative powers and duties, core duties. Keep trust property separate from their own, no mixing. And keep proper accounts, detailed records are essential.
Makes sense. What else?
Power to invest the trust property, big one, comes with that duty of care we'll discuss more. Power and often a duty to ensure trust assets.
Do they get help with all this? Delegate?
Yes, there's a power to delegate administrative tasks to agents, but crucially, there's a duty to monitor those agents properly.
Okay. Any others?
Might be powers to appoint new trustees, ask a court to vary the trust terms, maybe even move the trust to another country, exporting the trust. And if they hit a problem they can't solve,
Ask a court?
general duty to apply to the court for directions. And remember, non-trustees, like a settlor, might hold some admin powers too, usually seen as fiduciary.
Let's zoom in on investment then.
Yeah.
You said it's a big one. Lots of rules, cases.
Absolute critical area for exams. Key law. Trustee Act 2000, Sections 1 to 10. Key cases. Spate v. Gaunt, re. Whiteley for the historical standard of care. Then Bartlett v. Barclays Bank Trust for company shares. Nestle v. National Westminster Bank for modern portfolio theory issues. And Cowan v. Scargill for ethical stuff.
Got that list. Spate, Whiteley, Bartlett, Nestle, Cowan. What are the main duties when investing?
Two big ones. First, preserve the value, make it grow if possible. Second, act even-handedly between different classes of beneficiaries.
Even-handedness.
Yeah.
Balancing income beneficiaries against capital beneficiaries, like someone needing income now versus someone waiting for growth later.
Exactly. It's a balancing act. Some investments give high income but low growth, others the reverse. Trustees have to juggle these competing needs fairly, can't just favor one group.
Sounds difficult.
It can be. Historically, safety and income were often prioritized, but Harari settlement trusts suggested a move towards interpreting investment clauses more broadly, allowing a wider range unless clearly restricted. And now we have the Trustee Act 2000.
Right. So the Act, Section 3, general power.
Yes, Section 3 gives a very wide general power of investment. Trustees can invest like an absolute owner could. But there are limits, like generally only investing in UK land unless the trust says otherwise. Sections 8 and 9 deal with land specifics.
And the duty of care. Section 1.
Section 1, yes, and Schedule 1 imposes a statutory duty of care. Trustees must use reasonable care and skill, And importantly, it takes into account their own knowledge or experience.
So a professional trustee is held to a higher standard.
Yes, the standard expected of that profession. This duty applies to investment powers, whether from the act or the trust deed itself, but check the trust deed.
Ah, can it be excluded?
The duty of care can be excluded or modified by the trust instrument. That's a very common exam point, although courts tend to interpret exclusion clauses quite strictly.
Okay. What else does the Act say about how to invest? Any criteria?
Section 4 sets out the standard investment criteria, suitability and diversification.
Suitability. Suitable for the trust's goals.
Yes, consider the trust's specific needs, timescale, risk profile. And diversification, don't put all the eggs in one basket. Spread the risk. Plus, a duty to review investments regularly. Keep checking they're still suitable.
Makes sense. And advice. Do they have to get expert advice?
Section 5 says they must get advice from someone they reasonably believe is qualified before investing, unless it's reasonable not to maybe a very small fund or a very short-term investment.
So duty of care, suitability, diversification, review, and advice. That's the framework from the Act.
That's the core of it. And underpinning it all is that general standard of prudence from cases like Spate v. Gaunt and Rewhiteley. Acts like a prudent person managing their own affairs, but for the benefit of others. Not expected to be perfect or beat the market, as Chapman showed.
What if the trust owns a lot of shares in one company? Like a controlling interest? Any special duties then?
Yes, definitely. That's the Bartlett v. Barclays Bank situation. Trustees can't just sit back then. They have a higher duty to be informed about the company, maybe get representation on the board, get regular reports, be much more proactive.
Right. Can be passive shareholders if you hold the reins.
Yeah.
And Nestle v. National Westminster Bank, what's the main point there?
Nestle is interesting. Trustees breached their duty by misunderstanding the investment clause. They were too cautious, didn't diversify enough into equities. But the beneficiary's claim failed because she couldn't prove that a different strategy would definitely have produced a better result.
So breach of duty, but no provable loss linked to it.
Essentially, yes. It also touched on even-handedness, but it really highlights the need for trustees to understand their powers and modern portfolio theory and the difficulty beneficiaries face in proving loss.
Okay, last bit on investment. Ethical investing. Cowan v. Scargill.
Cowan v. Scargill, landmark case. Miners' pension fund trustees wanted to avoid overseas investments and investments in competing energy industries for ethical political reasons.
And the court said?
The court said no. For a pension fund, the primary duty is the best financial return for the beneficiaries. Trustees must put aside their personal views, political, social, ethical, whatever, and focus on financial benefit.
Pretty strict. Is there any room for ethics at all?
Cowan didn't completely rule it out. If, say, all beneficiaries felt strongly about an ethical issue and the financial impact was minimal, maybe. And Harris v. Church commissioners suggested for charities, ethical considerations might be more relevant if an investment conflicts directly with the charity's aims. But for most private trusts, Cowan holds financial benefit first. It's still debated, though.
Okay, that's a thorough look at investment. Now, delegation. You mentioned the Trustee Act 2000 changed things.
Yes, it made delegation easier and clearer. Sections 11, 12, 15, 22 to 27 are key. Section 11.1 allows trustees to delegate most functions to an agent collectively.
Most functions?
Yeah.
But not all. What's off limits?
Crucial exceptions in Section 11, too. Cannot delegate, deciding distributions to beneficiaries, deciding if fees come from income or capital, appointing new trustees, or anything the trustee or another law says can't be delegated.
So the really core decisions stay with the trustees.
Mm.
Who gets what, who runs the trust.
Exactly. You can delegate admin, but not the fundamental dispositive or trustee appointment powers.
Can they delegate to another trustee?
Section 12 says yes, you can delegate to a co-trustee, but not if that co-trustee is also a beneficiary. Conflict of interest risk there.
Right. What about delegating investment, Section 15?
Yes, Section 15 is vital for delegating asset management functions like investment. If trustees do delegate this, they must give the agent a written policy statement.
Policy statement. What's that?
It guides the agent, sets out the trust's investment goals, risk tolerance, income needs, any ethical guidelines perhaps, ensures the agent manages the assets in the beneficiary's best interests according to the trustee's strategy.
And once they've delegated, they can just relax.
No way. Section 22 imposes a duty to review the arrangements. Keep an eye on the agent, review the policy statement. Is it still working? Is the agent doing a good job?
And the duty of care applies here too.
Yes, Schedule 1, Paragraph 3. The Section 1 duty of care applies when choosing the agent initially and when reviewing them under Section 22. Due diligence throughout.
What about that older rule, Section 25 of the 1925 Act? Does that still exist?
Yes. Section 25 of the Trustee Act, 1925, is different. It allows an individual trustee to delegate all their powers and duties for up to 12 months using a power of attorney. Useful if going abroad.
All powers, even the non-delegable ones under the 2000 Act.
Yes, it's a broader temporary delegation by an individual, but they have to give notice to co-trustees and those who can appoint trustees. And crucially,
There's a catch.
Section 25(7), the delegating trustee remains liable for the delegate's actions as if they were their own. So you delegate, but you retain the ultimate responsibility.
Big difference from the 2000 Act delegation, where trustees aren't liable if they exercise due care in selection and review.
Exactly. Section 25 is riskier for the trustee.
So why delegate investment? Usually lack of expertise.
That's a primary reason. If trustees aren't investment experts, delegating to a professional manager can be the prudent thing to do to meet their duty of care. It can also be more efficient. But again, careful selection and monitoring are key.
So delegation is useful, modernized by the 2000 Act, but trustees must be careful what they delegate, who to, and keep reviewing. It's not an escape route from responsibility.
That sums it up well. Flexibility with accountability.
Okay, let's turn to the beneficiaries themselves, the people the trust is actually for. What rights do they have? Does it vary?
Hugely. It depends entirely on their position under the trust. Big difference between fixed trusts and discretionary trusts.
Fixed trust, where you know exactly who gets what and when.
Right. Beneficiaries there have a defined interest. It's basically their property and equity. They can usually sell it, give it away. It passes if they go bankrupt.
Okay, but discretionary trusts, where trustees choose from a class?
Totally different. A potential beneficiary there doesn't own anything yet. They just have a hope, a spiz, that the trustees might choose them.
So no property right they can sell.
No. But they do have rights. The right to be considered by the trustees, and the right to compel the trustees to administer the trust properly according to the rules. They can sue if the trustees misbehave.
What about objects of mere powers of appointment? Do they have any rights?
Very limited. Objects of general or hybrid powers, usually none. The class is too wide. People entitled in default of appointment. They have a right to make sure the power isn't exercised improperly, like a fraud on the power.
Right, because if it's used wrongly, they lose out.
Exactly. Objects of special powers are a bit like discretionary beneficiaries. They can complain about invalid appointments outside the class and insist a fiduciary power holder considers exercising it. But they can't demand an appointment.
But underlying all this is the idea that someone must be able to enforce the trust, that irreducible core you mentioned.
Absolutely fundamental. That quote from Armitage v. Nurse, there must be minimum obligations, like honesty, that beneficiaries can enforce in court. Otherwise, it's not really a trust. Beneficiaries are the enforcers.
And part of enforcing is knowing what's going on. What about their right to information?
Crucial area. Beneficiaries with vested interests whose rights are fixed definitely have a right to be told they're beneficiaries. That's Hawksley v. May.
What about discretionary beneficiaries?
It's generally accepted now they also have rights to information. Cases like Chain-Nixon v. Bank of Ireland support this. The court in Murphy v. Murphy even ordered trustee details be given. And maybe even those with contingent interests, potentially.
What information can they see? The accounts.
Yes, entitled to see trust accounts and core trust documents showing how the trust is being managed, usually at their own expense. And importantly, based on Armitage, this basic right to accounts likely can't be totally excluded by the trust deed. Accountability requires transparency.
But not everything. What about the trustee's private thoughts or reasons for decisions?
That's the controversial bit. Real Londonderry settlement is the classic case here. It said beneficiaries aren't entitled to see documents revealing the trustee's reasons for exercising their discretion, like why they chose beneficiary A over beneficiary B.
Why not? Seems relevant.
The court worried it would make trustees fearful of making decisions, constantly looking over their shoulder, and could stir up family arguments. Confidentiality allows for freer exercise of discretion.
But isn't that changing? What about Schmidt v. Rosewood Trust?
Schmidt suggested the right isn't strictly about property ownership, but about the court's inherent power to supervise trusts. So access depends on the circumstances. What's needed for proper administration, it's more discretionary. Objects of powers might get access if needed. But Londonderry hasn't been fully overruled regarding reasons for discretion, though cases like Breakspear v. Ackland show the court can order disclosure of reasons if needed to ensure the trust is working properly, perhaps to resolve a dispute. It's a balancing act.
Balancing trustee confidentiality with beneficiary accountability. Okay. Now, the big finale for beneficiaries. Saunders v. Vautier. What's the rule?
Saunders v. Vautier, a really powerful principle. If all the beneficiaries are adults, 18 plus, of sound mind, and between them hold the entire absolute beneficial interest.
So collectively, they own everything beneficially.
Yes, they can collectively tell the trustees, hand over the legal title, we're ending the trust. Even if the trust deed said it should continue longer, like until they reach age 30.
So they can override the settler's intentions.
If they meet those conditions, all beneficiaries, adult, sound mind, absolutely entitled, yes. If there's only one beneficiary who meets this, they can do it alone. It recognizes that ultimately the beneficial owners should control the property.
Are there limits? Can they always do it?
There are limits. For fixed trusts, one beneficiary demanding their share can't prejudice the others, as explained in Stevenson v. Barclays Bank. Easy with cash or public shares, maybe harder with land or private company shares where splitting might reduce value.
Okay. And discretionary trusts.
Much harder. Rees-Smith says all potential beneficiaries must agree. Given that discretionary classes can be huge and sometimes uncertain after McPhail v. Dalton, getting everyone together and agreeing is often practically impossible.
So Saunders v. Vautier is powerful, but mainly applies cleanly to fixed trusts with readily identifiable adult beneficiaries who are all in agreement, or a sole such beneficiary.
That's a good summary. It underlines beneficiary entitlement, but has practical constraints.
Wow. Okay, that covers a huge amount of ground on express trusts.
Yeah.
Really helpful, especially breaking down those key cases in Act sections.
I hope so. For anyone studying this, remember those key areas: rights and duties, the difference between personal property rights, the bona fide purchaser rule,
Trustee powers, dispositive versus administrative fiduciary nature.
investment rules under the Trustee Act 2000, duty of care, diversification, advice, key cases like Bartlett, Nestle, Cowan v. Scargill.
Delegation under the 2000 Act, what can't be delegated, the policy statement, duty to review. Contrast with the 1925 Act, Section 25.
And beneficiary rights, fixed versus discretionary, rights to information, Londonderry, Schmidt, and definitely Saunders v. Vautier.
Thinking about how these apply in exam questions, like the sample ones often provided, is key practice.
Absolutely. Working through scenarios really helps solidify understanding. And again, thanks to the University of London for making these materials available for educational purposes. They are excellent study aids.
Definitely utilize those resources. So quick recap. We've hit the blend of rights in trusts, trustee powers duties, the nitty-gritty of investment and delegation, and the spectrum of beneficiary rights culminating in Saunders v. Vautier.
It's a complex area, but hopefully breaking it down helps. As you continue studying equity and trusts, keep thinking about that balance.
Oh, yes, between what?
Between trustee discretion, giving them the flexibility to manage the trust effectively, and beneficiary rights, ensuring accountability and that the trust serves its purpose. It's a constant tension in the law.
That's a great thought to end on. How does trust law continue to adapt that balance, especially with things like modern ethical concerns or complex investments? Something to ponder.
Indeed.
Thank you for joining us for this educational deep dive using the University of London's materials. We hope it aids your studies.
Good luck with your revision.